Court is open. Please be seated.
So we're resuming with the fourth case on the list, AM versus KM, 25P 203. This is a partially impounded case, so I'll ask all the parties to be mindful of that.
Thank you, Your Honor, and I will. Good morning. May it please the Court, I'm Merritt Schnipper here today representing KM, the defendant in this restraining order matter.
Could you speak right into the
Yes,
microphone?
I'm sorry. The order at issue here permanently bars KM from ever independently speaking with or interacting with his children outside of his his former wife's supervision. That means that for the majority of their minority, in other words, half their pre-18-year-old lives, KM may not even be physically in his children's presence without committing a crime.
How old are the children now?
The children, I believe, at present are 12 and 8 or 12 and 9. This is a pretty significant deprivation. And this order was entered on a record that does not contain even an allegation or a claim of abuse by KM directed towards his children. It contains a single allegation of an act of abuse for which they were present. That allegation occurred in October of 2018, so roughly 6 years before the permanent order hearing at issue in this case. Throughout the balance of that time, there's not even a claim that there was any act of abuse directed towards the wife for which the children were present. The last claimed act of physical abuse that the wife alleges was in 2019. There's a restraining order itself in 2022. The ex parte affidavit was filed in January of 2022. It's my position that that affidavit doesn't actually set forth conduct that amounts to abuse under the statute. Now, we're not here trying to challenge whether that order should have entered. That period for that challenge has come and gone. But the case law is clear that we begin with the assessment of an extension or a permanency by considering the initial order and the basis for the initial order. That interaction, which was in January of 2022 in the midst of heated divorce proceedings, was an angry interaction about handing off children for scheduled parenting time. And it involved yelling, and it involved angrily banging on a door, and it involved taking a child outside.
We have a transcript of the hearing at which presumably the wife testified about those events?
We do not have that transcript. We only have the affidavit. But we have the affidavit, and then we, of course, do have the transcript of the permanent order hearing at which wife's counsel reached all the way back to claim that the acts of abuse that justified permanency were in 2018 and 2019. It certainly is a reasonable conclusion that anything more serious or more recent would have been brought up at that hearing for the simple reason that the goal of that hearing was to get a permanent order entered. So we're really looking at a well, there has to be independent support for an order that restricts contact with children that occurs in the context of an incidental restriction on contact with children that's in an order that only actually protects the former spouse. There was never a request for a protective order relating to these children specifically. This is only, I guess, up to permanent bar on in-person contact with your children, but only entered for the purpose, theoretically, of facilitating as necessary the protection of the former spouse. Now, it's worth noting that since the order, the initial ex parte and then appearance-based order entered in January of 2022, there's not even a claim of any threat or active abuse directed towards the former spouse by KM. There's only allegations of sort of unpleasant emails going back and forth. So there's really, there's fundamentally no basis on which to permanently bar this man from ever being.
What do you have to say to the wife's argument that the husband's avenue to have unsupervised access to his children is to abide by the order and get drug testing and therapy and then have supervised visits with the children and then seek to modify it?
The entirety of that procedure sounds appropriate for working towards changed custody terms in the larger family court matter. But what I say about the question of a restraining order that criminalizes contact or conduct, interaction with your children, is that it occurs, it's entered under a separate legal standard, it requires a separate form of proof or support. So there's two things. Are we counseling husband as to an appropriate way to kind of work his way back into a family relationship, that sounds like good counsel, Your Honor. But the question of whether there's support for a permanent restraining order here requires, as to the children, separate support. There is none. And with regard to the order just restricting contact with the wife herself, or the former wife herself, it requires a showing that as of April of 2024, when this permanent order entered, she had an objectively reasonable fear of imminent serious harm at her husband's, or former husband's, excuse me, hands. So I don't think that there's certainly no case law support for the idea that when the last sort of claim of physical abuse occurred 6 years ago, that there's an imminency, a reasonable imminency of a belief of serious physical harm. I mean, the paradigmatic case for where you never abuse somebody for years after seriously abusing them and the imminent fear of harm is still reasonable is Vitone versus Claremont. In that case, obviously, the abuse was exceptionally brutal, involving physical assaults and rapes over a course of years that then ended up becoming a criminal conviction. And when the defendant was finally going to be released from prison after serving his committed sentence, and the wife went to the family court to get an order restricting both abuse of both of her and her children, the court said, appropriately so, in light of the seriousness of this abuse, the shadow it casts really never is alleviated. But in this case, what you have is a single restraining order entered in 2022, no claimed acts of abuse in the interim. And I think, normally we're going to also look for whether there are existing violations of the order that's in place.
Well, isn't there an argument that the reason why there aren't any acts of abuse is because the restraining order is in place and is in fact effective?
Well,
and secondly,
Sure.
haven't there been violations, alleged violations
Absolutely.
since then
So that's where I was
involving the
going to. Let me
children?
take Your Honor's
So
first
if you could
question
just
first.
address those.
So it's certainly appropriate to note that there's one interpretation of this record, which is, wow, it looks like the restraining order worked. So if we leave it in place, at least there probably won't be any other abuse, right? Which is, of course, what we're trying to avoid. Now, we can look at the 3-year period between the last claimed act of abuse in 2019 and 2022 and note that there's no allegations of abuse in that period either, right? And of course, while it's certainly true that occurrence of abuse during the period of an order's pendency is not in and of itself reasons to vacate that order or not extend it, it certainly is a piece of evidence to consider, right? So with regard to the alleged violations of this order, of which there are several, I think I actually encourage the court to look into them, and they're recited by the wife's counsel at the restraining order hearing, because what they indicate, of course, that not a single one of them claims even any threat, let alone actual physical confrontation. They're all absolutely sad and pitiful attempts by this man to speak with his children. He has actually been charged with a crime for admitting, there's no witness to this event other than his own admission, but he's just that kind of guy, just admitting to his wife's lawyer in an email, I attended my daughter's soccer game, and during that game I went up and I spoke to my son. And that's a crime under this order. And there is literally, if we take the standards of law that apply to this area seriously, and we take the magnitude of the deprivation that this man is suffering seriously, we're talking about a period of between 8 and 10 years looking forward under the permanent order that he may not even be in his children's physical presence, right? They lose their father on a record that does not contain a single instance of either serious abuse witnessed by them, any abuse directed towards them. What are we to do with that, right? That there is simply no standard, there's no lenient standard of review under which you can leave in place. Like now I'm just talking about the order with regard to the children. There needs to be independent support for it. There simply isn't any. There's not an iota of independent support for the belief either that these children are in danger or that this level of draconian criminalization of a father's relationship with his children is necessary to protect his wife. Now, with regard to the order, the permanent order vis-a-vis wife, which is, basically the court has significant discretion to enter, you're still looking at a situation in which there's not even any serious claim going back to 2019 of actual abuse, right? There's a 2022 affidavit that talks about angry exchange of children. That's it. And then in the aftermath of that, there's a well-being check, everybody's fine. So again, it's all well and good to say that the way to work your way back is to start participating. I support that myself. But we're talking about an order that criminalizes contact, and there has to be a very specific set of proofs offered before that can happen. And it's simply not present here. I think it's useful to think about the type of record that can support at least a temporary restriction on contact with children incidental to the protection of a former spouse. Schechter v. Schechter, this court's decision gives a pretty good example of that. And in that case, you have an 18-day trial with over 30 witnesses and 300 findings of fact, including that the husband called up the wife and said, I'm going to come over there and chop you up with an axe, right? In that context, it was reasonable to impose a 1-year restraint on contact with the child in order to facilitate the overall settling down after an angry divorce proceeding. That's not what we have here. We have no physical threats. We have no physical interactions. And what we have is a person who, on the basis of, and it's certainly true that counsel below stipulated, let's just go forward on attorney representations, but there's never been a single piece of testimony about anything in this case. And the idea that this man can be permanently precluded from ever interacting with his children without any shred of meaningful evidence and criminalized to simply send your child an email. That's a crime.
Was it an abuse of discretion to enter this order if it just related to the wife or the mother?
I do believe it still was, but obviously it's a much closer call given the leniency with which, the person who's actually protected is viewed. So I consider that to be an abuse of discretion because you need an objectively reasonable fear of serious imminent physical harm. Where does this exist on a record where these parties, the divorce is concluded, right? So that stress-inducing cause is not present. There is no claim of a physical threat since 2019, 6 years, 5 years, right? I mean, what would make her present fear objectively reasonable? And what would countermand, I think, the very obvious indication from this entire record that this is one of the frequent uses of 209A orders in the context of larger family dissolution issues, where they're really used instrumentally to gain leverage over the other party. And that worked here. This man is completely banished from his children's lives. And I think the question for this court is that conscionable under the applicable standards set forth by this court's decisions in the SJCs? And I would say it unquestionably is not. We don't have a single indication that depriving these children of their father is necessary to either protect their mother or to preserve their own well-being. In fact, I would assume, and I wouldn't even just assume, I would posit that the permanent deprivation of any in-person contact with a parent, absent a showing of grotesque abuse, is of itself inimical to a child's welfare, right? I mean, children need their parents. And none of that, there's supposed to be independent consideration by a restraining order court of the relationship between the parents and the child, separate from the consideration of the relationship between the spouses. There is not a shred of indication in this entire record that there is any consideration ever of these children's relationship with their father.
But how do we know that without the transcripts from the previous restraining order
From one single hearing? I mean, because we have the judge's questions at the permanent order hearing. We have the contents of the affidavit. The idea, and again, like, if there was something meaningful to be found, nobody's prohibited from ordering another transcript and submitting it to the court, saying this is the complete record you need to consider. The magnitude of this deprivation simply is not. This is not the type of case where you can just say, well, there's a missing transcript. Sorry, we're just going to leave in place the permanent dissolution of the parent-child relationship. I just don't think that that is what the law permits, and I don't think it's something that any court can do in good conscience.
I have a question for you about the admissibility of the partial transcript of the criminal trial.
Sure.
Was the wife represented by counsel?
I mean, just the prosecutor. And I think one of the things that's since you brought that up, Your Honor, I think one of the things that's most notable about that is that obviously that the prosecutor wasn't representing her, he was representing the government.
Sorry, I can't hear you.
I'm sorry. The prosecutor was not representing wife, he was representing the government's interests at that trial, but they were pretty overlapping given that the prosecutor was attempting to convict KM of an act of domestic violence against wife. And on direct examination by that prosecutor, the wife was completely equivocal about whether he even struck her, which I would submit is the primary reason.
Do we have the transcript of the required finding argument or the closing arguments so that we could judge how strong the Commonwealth's case was?
Well, you have the entirety of the evidence. No, you don't have the closing arguments. I'm happy to submit that if you'd like, but you have the evidence in the case. Because the point here, and the reason that it's an appropriate consideration and expansion of the record, is that it's the only time there's any testimony available from either of these parties about the incidents underlying this restraining order, and that's what the case law I cite in my motion to modify the record says, is like that's when it's appropriate to expand, when that testimony in a related action between the same parties can provide insight into what's going on. So I see my time is up, and I don't sense any further questions coming from the bench, so I'll just ask that you vacate these orders. Thank you.
Thank you.
Good afternoon. May it please the court. Dana Curhan representing the mother. Regarding whether the order properly applied to the children, that order entered in 2022. The father never appealed that decision. The father also did not appear at the 2023 extension order, so my contention is that that issue is waived. I think the father also had the burden of providing this court with an adequate record to challenge the order, and I think the attempts to challenge the initial order, again, are waived, but there's not a sufficient record to do that.
Well, we have a record of the order that's being challenged.
We do have a record. To the extent that the father is trying to challenge the initial order and say that there's insufficient evidence to issue that order as to the children.
I don't think I viewed the argument as such, but if we just look at the record of the order that's being challenged, where is there evidence regarding the need for the order with respect to the children?
Okay, four things. First, on 2 occasions, the father placed the son in physical danger. On 1 occasion, he grabbed him out of the car, punched the mother, ran off down the street, and that was in October of 2019. On January 21st, 2022, he grabbed the child from the home. It was 11 degrees out. The child had no jacket, no shoes. He ran down the street and took off and said, "You'll never see your son again." And the next day, he didn't bring the child to school. That's what actually prompted the mother to go in and apply for the initial restraining order. So, those are 2 incidents that put the child in danger. Second, the father either refused drug tests or failed drug tests. We're not quite sure which, but there are orders in place for him to submit to drug testing. And I think before he comes in and challenges the order or waives his constitutional or raises his constitutional rights as a parent, I think he's got to take the drug tests, and I think he's got to pass the drug tests. Third, he has repeatedly violated the orders in place as to the children and as to the mother. He has contacted the children and said, things to the effect of, guess which parent is preventing me from seeing you, and there are communications permitted, the daily FaceTime calls, which my understanding is he has not really been participating in those. And there are mechanisms in place for him to reestablish contact with the children. In particular, he can submit to supervised visitations, which, as usually happens, can lead to unsupervised visitation and something, more substantial. He hasn't done that.
But these arguments all seem to be going towards the sorts of issues you'd be dealing with in the probate and family court rather than, They seem to be separate and apart from this issue of a complete ban on contact.
Well, there is no complete ban on contact. There is something in
Well, it's
place.
just, it's FaceTime, a video, that the father can't physically see or be in contact with the children, right?
Well, under the FaceTime order, that's an exception to the order. No, he can't. He'd be on screen. Now, he has been offered supervised visitation, which he will not submit to.
But what does that have to do with, I mean, just to follow up on Justice Singh's point, because as you were reciting all of the things that the father hadn't done, not taking the drug test and some of the other things that you mentioned, aren't those things that are actually usually addressed through sort of visitation orders and litigation in the probate court? Again, I guess I'm sort of repeating Justice Singh's question, probably not as artfully, but as opposed to, a permanent restraining order.
Well, they are, but the restraining order was issued by the probate court. And, that's one of the options, and it's our contention that the father has been placing, or potentially has been placing, the children in danger by not submitting to drug tests, by, what he did to the son, and,
So if he submitted to the drug test, then would that somehow address or ameliorate the concerns about, that led to the restraining order being issued in the first place?
well, I mean, it might, but...
Or extended, rather?
I mean, I think a lot of times you have a 209A issued by a district court, and you have orders in the probate court. These are all in the same place. So I think a probate and family court judge can look at this and say, okay, he is on a path toward reestablishing a connection with his children. And, that might have some persuasive effect on the judge. But the question before this court is, did the judge abuse her discretion by issuing this order and by making it permanent? And as to the children, I mean, at the time this permanent order entered in 2024, there were somewhere between 4 and 6 violations that were pending. The father does not want to follow the court's orders. If he wants to reestablish a connection with his children, he needs to follow the court's orders. And those orders are in place for the benefit of the children. I think telling the children that, your mother is the one who's preventing me from seeing you, I mean, that doesn't necessarily put them at risk of physical harm, but it does establish that he's not willing to listen to the court's orders. He's not willing to follow them.
So perhaps the restraining order isn't the remedy to compel compliance with the court's orders. I mean, is that how a restraining order is supposed to be used?
That's not the way it's being used here. The way it initially was used is because the mother was concerned with the son's safety when the father grabbed their son and ran down the street with him and didn't bring him to school the next day. I mean, he was in some danger. It's debatable as to how much danger, but she was legitimately concerned. She had the police do a wellness check on him, and she immediately went in there and got a full custody order the next day. But the restraining order was certainly part of it, and I think it was well within the judge's discretion. And again, we don't have those transcripts, but I think it was well within the judge's discretion to say, I'm going to issue this order, and it's going to include the children.
This might be asking the same question a different way. A probate and family court judge presiding on a divorce has all kinds of mechanisms to help her or him in deciding child custody issues. Having a trial, having GALs, having experts testify. We don't know any of that in this case. We don't have the record of the divorce proceedings before us. All we have is the record of the restraining order proceedings. Isn't that part of the problem here, that we can't, we're only deciding the restraining order case?
Right. It may be that, and I acknowledge that we're handcuffed by the lack of an adequate record. We're not the appealing party. The father is the appealing party. He has the burden of providing this court with an adequate record. He has not done that. So, that's why the court is handcuffed, I'm handcuffed. I can only respond to what is in front of me. And I'd say what is in front of me, I think the fact that when the first time the father grabbed the son and ran down the street, it was also in the context of a fight in which the father punched the mother in front of the children. And, that is, I think it's reason number 4 why that order was properly issued. So, again, the father does have the opportunity to go in and challenge this order once he has gone through steps and established some contact and established that he is a safe person for the children to be with, which he has not. And so I think that's problematic.
When you mentioned that at the time the order was made permanent, you had a number of open matters. Did any of them deal directly with the children?
Yes, 3 of them did. And we don't have a record, but there's some discussion in the transcript. The mother's counsel said there were 4 of them. The judge said, no, there are 6. And so my understanding is that the orders regarding the children were, contact outside of the permitted channels, outside of the FaceTime calls. Make sure your mother's not around when you call me. That's not, so those resulted in violations. And the other thing is, as to the mother, there are communications permitted through My Family Wizard. There were communications outside of that, basically abusive emails, and I don't know if any, well, there don't seem to be any threats of physical violence. There were threats of reporting my client to bar counsel and things like that. But those communications were not permitted under the order. He had a particular mechanism of communicating, and going outside of those, that's a violation. And those were all pending at the time the order was entered. The order was extended. And, I come up here a lot and say, look, during the course of divorce proceedings, one party or the other goes and gets a restraining order to get an advantage in the divorce proceedings, and after the parties have separated, there's no need for that. The temperature's cooled off, there's no conflict, and everybody's getting along. That hasn't happened here. The temperature has not dropped. My client's address has been impounded, and so the father does not have access to that. And that's probably why she's safe. But, she expressed some real fear at the order, continuing fear, even though she hadn't been physically abused for several years. He hasn't been particularly pleasant to her. He hasn't followed the orders as to her. And why does she need to go in every year and ask that be renewed? I think the judge can certainly say, I'm going to make this permanent. This doesn't seem to be resolving itself. He's not getting drug testing. He's not doing all the things that we ordered him to do. He's not following the 209A order. He keeps violating it. So, the question is, did the judge abuse her discretion in making the order permanent? No. Unless there are any, I just want to mention very briefly on the motion to expand the record. These things were all in the possession of the transcript and the police report. They're all in the possession of trial counsel, the husband's trial counsel. She made a tactical decision not to introduce them, but she also kind of summarized what they were all about. I think when you look at them, I don't see how they really help the father. They kind of indicate why she acted the way she acted, but I will leave that to the court's discretion.
Thank you.
Thank you.
Thank you to the parties. Case has been submitted. The next case on the list is David Ladd versus ALINA BOSCH, 24P 1175.
May it please the court, Philip Giordano representing the appellant and the defendant, ALINA BOSCH. We are here asking the court to reverse certain errors that occurred in the Superior Court. The Superior Court erred in denying Ms. Bosch's motion for a directed verdict and a judgment notwithstanding the verdict regarding the abuse of process claim. As we've put in our briefs, the third-party defendant, Ralph Ladd, failed to introduce any evidence establishing that Ms. Bosch used process for an ulterior or illegitimate purpose. The trial court erred in concluding that groundlessness or insufficiency of evidence in Bosch's claim against Ralph Ladd proved his abuse of process claim. Ralph Ladd's three theories, the scapegoat theory, the revenge theory, and the leverage theory, are not within the law on abuse of process. The court also abused its discretion in allowing Caroline Ladd's testimony regarding Ralph Ladd's health and his damages. Number one, on the invoice issue, which is the invoice of counsel for Ralph Ladd and David Ladd. The invoice, as we described in our brief, was hearsay. It was deemed inadmissible. It was deemed not kept in the ordinary course of business, and it was not allowed. But there was no indication whatsoever as to Caroline Ladd's basis for simply reading when it was stuck before her during her testimony and then quoting the number. And conveniently, that number, down to the penny, is precisely what the jury came back as damages.
Well, Caroline Ladd initially testified when asked how much in legal fees has Ralph's plumbing business incurred, and she said approximately $235,000 without objection. Was it error for the judge to allow that to stand?
Absolutely. Because
The judge sort of sua sponte stricken it.
It should have been stricken, Your Honor, because we had objected repeatedly to Caroline Ladd's being able, without any foundation, because it's still a hearsay, and it's based solely upon a document that was generated for trial, which is identified only by ID. It was not admitted into trial. However, that alone also should have been stricken because it was inconsistent with the trial court's prior ruling regarding the number. And the invoice itself is not an invoice. It says abuse of process damages on page 15. It is shown to Caroline Ladd, and it's not used to refresh her recollection. It is merely something that was, if you look at the document, it was something that was merely shown, and it is generated for trial. Page 15 of that document specifically says, at the bottom, abuse of process damages equals $250,000 plus. And then it talks about the additions and whatnot. This is allegedly an invoice which was prepared, not provided in discovery, sent over on a Sunday, the day before the testimony was occurring. You have entries that are cut and pasted out of masscourts.org. You have 3 years, 2019, 2020, 2021. It says to be processed. This is not an invoice. It's a piece of paper that's generated simply to try to find some way to
Was
get
that
a
admitted
number.
at trial, that piece of paper?
I'm sorry?
The judge didn't admit that piece of paper at trial?
No, but the judge did say the way you could get around it was that you could have Caroline Ladd testify, and
So my
that was
question-
inappropriate.
My question for you is, I don't see where the piece of paper that Ms. Slaughter used in questioning Ms. Ladd, I don't see where it was ever marked for identification.
It was
and-
marked
and-
for, it's in our brief, I think it was either D or E.
I understand it's in your brief, but my point is, why is it in your brief if it wasn't marked for identification at trial? How do we know that's the same document that was used?
Are you talking about what was submitted as D? The original D with the sticker of D, as compared to what this was? I'm a little confused, Your Honor.
There's something at RA pages 84 to 98,
Yes, that's what I have.
and I don't know where, I don't see in the transcript where that was ever marked for identification.
It was that sidebar that the judge, I apologize, I don't have the page before me, but I do know that I was there. I was the trial counsel at the time. And we, knowing that this would be an issue, asked that it be marked for identification. There was a little confusion in terms of some of the exhibits with the clerk, because some of the ones that were marked for identification, in terms of some of the shuffling, I recall that very specifically.
Can a business record that's an account payable of one business, can an account payable document be a business record, or is it only the account receivable of the issuing business?
The law is, for an ordinary business record, is you have to either perform the services or you have to be the recipient or the generator of it. Ralph Ladd, who was the alleged person, now this is supposed to be an invoice to David and to Ralph. Ralph Ladd could not testify about the amount of money. He was the only party.
Well, but Mrs. Ladd, Caroline Ladd, was the bookkeeper for Ralph's plumbing business for 62 years. Are you saying she wasn't qualified?
She was not qualified on a document that was generated the day before trial. This document was never submitted to Caroline Ladd. There was no evidence whatsoever that she received it as a bookkeeper. It was because all you have to do is look at the
Was she
content.
cross-examined about that?
Was she examined about that?
Was she
That
cross-examined? In other words, my reading of her testimony is that she said she kept the books for 62 years, and that the Ralph's plumbing business incurred about $235,000 in defending against the abuse of process claim, and then she's shown a document, and she testifies to the specific amount, and she repeatedly testifies that it was her understanding that that was the amount that Ralph had incurred in defending against the abuse of process claim. Now, to the extent that maybe she could be cross-examined about how does she know that some of this isn't for David, I don't see where she was.
Well, respectfully, the examination, which is on TR 1569 through 71, is a short examination. She was not repeatedly saying this is the amount. The document itself speaks for itself, and it says, as of May 28th, that's a Sunday, it's not something that's invoiced, it's also after a week's worth of trial, when Ms. Ladd is then testifying the following day.
But how is the defendant prejudiced if that's not before the jury?
I'm sorry?
If that document that says as of blah, 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 which is a Sunday, if that's not before the jury,
But the content is then mimicked and quoted. An attorney for Ralph Ladd specifically said, without asking to refresh her recollection, there was no indication she needed to have her recollection reset. It's in our brief at TR 1569 through 71. Ms. Ladd, do you recognize the document that I showed you? Caroline Ladd, yes. What is the document? It states the amount of hours, work that was put into the trial. It says specifically in the trial, which was ongoing, and the case. Attorney Slaughter, page 15 of the document I just showed you. Does that state how much Ralph Ladd has incurred in legal fees in connection with this litigation? That's inclusive of the trial.
so you're saying
by her
that
own
that's not refreshing the witness's recollection?
You have to demonstrate a lack of recollection to have something to be refreshed. You can't
She
just
said
simply
approximately
sui sponte say-
535.
I'm sorry?
She said approximately 235.
She
Does-
says 232, 715
but
on page, I'm sorry, 1571.
Page 1569, she says, I would say approximately $235,000.
In 1571, she says 232, 715, which curiously is the precise number of a piece of paper generated inclusive of trial. That alone is hearsay. It is an out-of-court statement. She didn't perform the services. She didn't have anything to do with the services. The invoice is rendered to her husband. He is not, this is not in accordance with his business. This is a legal bill regarding something else. And to say that that is not an out-of-court statement for the truth of the matter asserted respectfully is precisely why the hearsay rule. And that also goes to the Abkarian case, in which roofing invoices were submitted, and those were deemed to be, he did not have the actual records. Now, the record also reflects that counsel, myself, actually moved the court when there was an indication that there was going to be some effort to try to put in damages. Originals, where is the original documents, the original time records? They reply in their opposing brief that the contemporaneous time records were maintained and there was just a failure to hit send on some button. We moved and requested those to be submitted, an engagement letter, anything else that demonstrates. This document, its unreliability, is clearly demonstrated by the fact that it is cut and pasted from the court docket. And there are time charges that are allegedly just from the court docket. It is clear there is at least, we identified in our motion for miniature, 43 entries that were either false or completely incorrect. For the simple fact of the matter is, they related either to David Ladd, which this is an invoice generated, and there's no indication it was sent to even David Ladd. But 43 entries were clearly not in accordance
So
with
my
any...
question again is, why didn't you cross-examine Caroline Ladd to say, isn't it true that this document includes entries for David Ladd?
For the simple, because, Your Honor, to either re-emphasize it, so in terms of whether we had preserved the issue or not, we had preserved the issue with the judge. We can highlight it and emphasize it to the jury as compared to asking either on directed verdict or other motions, post-trial motions. So to say that that issue was not preserved, I think is simply incorrect, and it's clearly contrary to the law. To have a...
Did you argue in the trial court that the testimony of Caroline Ladd wasn't the best evidence, only the document was?
We said the original records needed to be produced and verbally moved to compel them. That is the law. That is Abkarian versus Public Service Mutual Insurance Company. We cite it and we quote it in our brief, and we say specifically, the case law says the plaintiff failed to introduce the actual records. This is something allegedly created from what they characterize as contemporaneous time records. We had a right to get the contemporaneous time records. We certainly asked in discovery all documents relating to damages. This was going to be damages. We were clearly prejudiced in, after a weeks of trial on a Sunday, this piece of paper, set of pages is emailed, and then the following day are being expected to cross-examine upon it. This is clear error contrary to the law. It was hearsay. Best evidence, where are the actual time records? Do they even exist? They have never been produced at any point in time. Where's the engagement letter? Where is any of the metadata to show that it was not even changed? It was not, when the cut and pasted occurred. So it is clear that as this case was winding up, because Mr. David Ladd went first, then ALINA BOSCH as defendant went next, and that portion of the case was winding up, counsel, realizing the Ralph Ladd claim is the next on the queue, realized there's no evidence that's been ever identified in any trial conference, any exhibit, any discovery process to show damages. And on a weekend, that's when they say, oh no, we have to create some basis for damages. The court had an obligation to correct that on post-trial motions. And we filed a miniature motion. We identified 43 instances where the document's unreliability was clearly in error. We identified the fact that it was inappropriate. Caroline Ladd was specifically testifying regarding all sorts of issues that do not come out of that document. Just briefly, since I see I'm already running out of time. We have 3 theories, allegedly in this case. 2 of them we can dismiss as a matter of law without even discussion. Scapegoat theory. There is no indication because ALINA BOSCH allegedly was trying to get money from her dad to help pay for repairs that has any ulterior or illegitimate purpose. The scapegoat theory does not even belong. Number 2, the revenge theory. That clearly is straight out of the case law. If it is harassment, oppression, or vexation, that is specific, that's part of litigation. Those 2 do not even belong. The third one, which is the termination email. The email does not even mention David Ladd's father. There is no reference. It is number 16. You specifically have to ignore the leverage theory. It is 2 months before David Ladd filed suit. It is 3.5 months before there was a counterclaim or third-party complaint ever filed. This email does not mention Ladd, does not mention anything whatsoever. I'll just summarize on the brief since I have 16 seconds left. Clearly, there is no basis whatsoever to talk about Ralph Ladd's stroke causation. We'll rest on the brief on that. And there is no basis. We also have a motion to strike with respect to David Ladd, and procedurally, he should not even be here with respect to the New Hampshire Consumer Protection Act. There was never any effort to brief him. That part of the case should not belong, and the court erred in that. I'm available. I see I'm out of time, but if the court has other questions, I'm available to answer those questions.
Thank you.
Thank you.
Good afternoon, Justices. May it please the Court. My name is Shannon Slaughter. I represent Ralph Ladd in this appeal. The standards of review for the issues raised by Ms. Bosch in her appeal are very high. With regard to the first issue, the denial by Judge Barry Smith with regard to the motion for directed verdict and judgment notwithstanding the verdict on the abusive process claim, Judge Barry Smith was properly denied those motions. The controlling case here is the Powers versus Leno case, in which an abusive process claim was determined by the court a little bit procedurally on different grounds. The judgment notwithstanding the verdict was granted in the lower court, and on appeal, the court said that that is a question for the jury. There was a statement made by Leno in that case where he said that he would keep the property tied up in litigation for years. And the statements made by Ms. Bosch in her termination email are similar here. What she said to David Ladd was that it would be cheaper to reimburse her for what she was referring to as some damages, but also when you look at the actual records of this case, she was looking for David Ladd to reimburse her for things that she never engaged David Ladd to perform. What she wanted to do here was to gain leverage over David Ladd by including his father, Ralph Ladd, in this case. Ralph Ladd had no business being in this case. So Justice Barry Smith's decision on the judgment notwithstanding the verdict and the directed verdict for Ralph Ladd were proper. Can
you address opposing counsel's argument regarding Caroline Ladd's testimony?
Absolutely.
And why it's not, you're arguing that it's not hearsay and it was admissible, correct?
Yes, Your Honor. So the controlling case on that, I believe, is a Brossi case. It was the decision is an appellate decision case that was affirmed by the appeals court. And in the Brossi case, the court said that even if the documentary evidence isn't admitted, it can be proven by other alternative. I'm sorry, this is not the Brossi case I'm referring to. It's the Akbarian case my brother referred to. The Akbarian case said that even though the documentary evidence wasn't admitted properly, it can be proved by alternate sources, including testimony. And that's what Justice Barry Smith allowed to happen here, was for Caroline Ladd to testify about the amount of legal fees.
It wasn't the testimony based on hearsay?
Your Honor, in the document itself, the number, yes, I would say that the contemporaneous time entries may have been hearsay, but Caroline Ladd was not simply a client in this matter. She effectively acted as a paralegal.
But what was her basis of knowledge for what she testified
worked
to?
alongside Attorney Patrick Sullivan throughout the entire case. She testified during trial that she was there every day. She knew exactly what was going on. She was very familiar with the case and effectively acted as a paralegal. So it wasn't as if Patrick Sullivan submitted an invoice to her and she looked at it. She was involved every single step of the way, and there was testimony from her about that at trial. So when you look at the numbers, when she said approximately $235,000 in legal fees was incurred, if you break that number down over the course of 6 years, which is what we have here, it comes out to about 9 hours a month. It's not very hard for Caroline Ladd to keep track of 9 hours of attorney's fees, which she knew was being billed at $350 an hour, to come to the amount of $235,000 a year. Now, I understand that the court did not allow the documentary evidence of the invoice in, and the basis for that was disclosure issues. It wasn't because it wasn't a business record, it was disclosure issues, and the court had ruled both ways on disclosure issues leading up to trial. So he said, and what the Brossi case says, is that if there is independent evidence, if there is another basis for the admission of this evidence, not just in the documentary evidence, that is proper. That's also in the Viper Ventures case, which is cited in our brief. In the Viper Ventures case, Ralph Caruso was an owner of property, and there were rent payments that were due from guarantors. There were also costs of repair. Well, in the Viper Ventures case, which is cited by both parties in their brief, Ralph Caruso was permitted to testify about the amount of rental payments that were received. However, in a different context, where there was a chalk that had interest calculations and all sorts of other calculations done by Ralph Caruso and his counsel in that case, he didn't have an independent basis, an independent knowledge for those numbers. So the court did not allow testimony from Ralph Caruso about that, and also did not allow testimony about that because the records on which the testimony was based, he said, I left them at my office. They weren't available for cross-examination. They weren't available for they weren't disclosed to counsel. That's not what we have here. These records were available for examination. Attorney Sullivan was there. He was ready to testify. Attorney Giordano moved to preclude him from testifying. So the circumstances in the Viper Ventures case as to the repairs and the costs that were not permitted via testimony, that's not what we have here. Rather, what we have is Caroline Ladd, which is more akin to Ralph Caruso's testimony about the rental payments in the Viper Ventures case, and that was properly permitted. Justice Barry Smith properly decided these issues based on the law, and there was no abuse of discretion. That's the standard we have to look at here. Was it an abuse of discretion for Justice Barry Smith to allow the testimony of Caroline Ladd, who had an independent basis for this knowledge, to testify about the numbers contained in those documents? With regard to,
What do we do with the fact that at various points early in the trial, Judge Barry Smith said, should I bifurcate the issue of damages, or I guess he called it legal costs for abuse of process, and reserve that to myself? And then Bosch's counsel said you shouldn't give any damages. If the Bosch's counsel had said, okay, you can bifurcate, we would have sidestepped this problem.
Yeah, I agree, Your Honor, and actually we asked for the bifurcation because of the potential of calling Attorney Sullivan as a witness, and he was counsel at trial for David Ladd and also Ralph Ladd. So we had asked for the bifurcation.
So how does an abuse of process, I'll call it plaintiff, just to simplify, prove damages that are legal costs?
It was a quandary that we had to deal with at trial, and I believe Caroline Ladd, who was the bookkeeper for Ralph Ladd, with the independent knowledge of what her and her husband were having to pay for legal fees over the course of 6 years, that is how that is entered into evidence if counsel is not allowed to testify under ethical rules or whatever else it might be, and the trial's not bifurcated. And with regard to reserving the issue, I suppose it's a little different because it's not legal cost versus attorney's fees under 6F, so they're overlapping, but it was an issue that we were trying to deal with at trial too, as to whether Judge Barry Smith should have bifurcated and retained that issue for himself, Your Honor. And unless there's any other questions with regard to Caroline Ladd's testimony, I'd like to move on to the abusive process claim and the three theories. I think the most glaring theory is the leverage theory. And as I mentioned, the Powers versus Leno case, it is an ulterior purpose to drive litigation fees, to keep people wrapped up in court. That is an ulterior purpose and motive. My brother argues that essentially there needs to be direct evidence. And ALINA BOSCH's email to David Ladd saying that it'll be cheaper to reimburse her than it will to litigate against her. She made good on that threat, not only against David Ladd, but then she included Ralph Ladd to try and get David Ladd to drop his claims against her for his unpaid bills, to reimburse her for things that she did not contract with David Ladd, nevertheless Ralph Ladd, to do on this Dunbarton property. And let's see. With regard to the scapegoat theory, Your Honors, perhaps this is not nomenclature, but semantics that unartful on my part, but the scapegoat theory, essentially we're arguing that ALINA BOSCH needed to get money from her father. She told David Ladd 3 days before terminating him that she didn't have money to pay him. She ran out of money. She needed to get money from her father to move forward with this project. She had to blame somebody but herself and her excessive spending in order to get that money from her father. And that's exactly what she did. She pointed the finger at David Ladd and she pointed the finger at Ralph Ladd and said, they are the reason that this project is costing so much money. But when you look at the actual invoices that David Ladd charged her, the actual invoices that her subsequent contractors charged her, these are for upgrades that she never, not all of it, but most of it, much of it, is for upgrades that she never contracted with David Ladd to do. Nevertheless, Ralph Ladd, she never contracted with Ralph Ladd for anything. So to that extent, ALINA BOSCH argues in her brief that the timing of this theory doesn't work, but that's not accurate. ALINA BOSCH testifies that she got a bridge loan from her father before terminating David Ladd, but as I just mentioned, the actual evidence in the case, aside from ALINA BOSCH's testimony, was that she didn't have money 3 days before terminating David Ladd. She hadn't gotten a loan from Cambridge Savings Bank that she said she was going to get, and she hadn't gotten money from her father. She needed this money, and that is why she pointed the finger at David and Ralph Ladd in order to get the money from her father. That is an ulterior purpose that is not properly part of this litigation, and the claims against Ralph Ladd were not properly asserted. And I would also posit, Your Honors, that direct evidence of this is not needed. So while we do have the termination email from ALINA BOSCH saying that she's going to drive up these litigation costs, essentially, there can be inferences that are made by what is done with the process that is used. And what was done here was ALINA BOSCH filed a complaint. She named Ralph Ladd as a sole proprietor. She recognized that Ralph Ladd didn't have anything to do with this. She testified time after time after time during trial. She never spoke to Ralph Ladd about the project. She never asked him to do anything. She never paid him for anything. Ralph Ladd had nothing to do with this project. She recognizes that in her complaint, yet on summary judgment, she says Ralph Ladd is business partners with David Ladd, and he was involved in this project with absolutely no basis to do that. The continued use of process throughout this case against Ralph Ladd is an ulterior purpose. It's extortion, essentially, and that's what an abusive process claim is, and that is why the jury properly found in favor of Ralph Ladd on this claim. Judge Barry Smith found that there was precious little evidence against Ralph Ladd in this case, and yet ALINA BOSCH continued to pursue her claims against him anyway.
Could you talk a little bit about rascality?
The New Hampshire Consumer Protection Statute, yes, Your Honor. With regard to Ralph Ladd, there can be no rascality. He didn't do anything. He wasn't contracted with ALINA BOSCH. He didn't speak to ALINA BOSCH. He didn't perform any work for ALINA BOSCH. He did nothing in Dunbarton, and that was the basis for the abusive process claim. And the same standard that is applied to Justice Barry Smith's decision on the Consumer Protection Statute is also applicable to David Ladd. So the rascality standard and what Justice Barry Smith decided is not confined by the jury's findings against David Ladd. He was within his discretion to make his own findings as to whether the conduct of David Ladd amounted to rascality. And he says that in his decision, that he was not confined. He would be, I think the term he might have used was advised, or he would be taken under advisory as to the jury's verdict against David Ladd. But it is within his discretion to determine whether that rises to the level of rascality. And what he said was that David Ladd got in over his head. He, even if there was a finding of misrepresentation against him, that didn't rise to the level of rascality needed to violate the New Hampshire Consumer Protection Statute. And if there are no further questions, Your Honor, I would rest on my brief.
Thank you.
Thank you.
Just ask the panel questions. Okay. All right, thank you to the parties. At this point, the matter is submitted. And we move to the next case. Charles ZAMMUTO versus Paul Damianidis, trustee of EKG Realty Trust and others, 25P 214.
Good afternoon, Your Honors. May it please the Court, Philip Cahalan for the plaintiff appellant, Charles ZAMMUTO. Your Honor, there are two essential contracts that are before you on this appeal. One is the settlement agreement of the underlying litigation, and the other is the contract in the underlying litigation, a purchase and sale agreement of commercial property in Ashland. With respect to the settlement agreement, if obviously we prevail on the settlement agreement, we don't need to get into the underlying trial. The matter is resolved, and we just ask for a simple breach of contract on the settlement agreement. The settlement agreement called for $100,000 to be paid to Mr. ZAMMUTO if certain conditions were met on the transfer of his special permit to the person who sought to buy the property that Mr. ZAMMUTO had been seeking to buy from the defendants. The trial court denied it by saying, first of all, that it was moot because it was not timely. And the simple answer to that is that it is a breach of contract seeking damages. We weren't seeking injunctive relief. The time for performance under the agreement, we couldn't perform the agreement at the time we brought the motion because the special permits had lapsed, probably about 6 to 8 months before the date of the hearing and the trial.
So you're saying that the judge erred for finding it moot and analyzed it under like a specific performance analysis as opposed to?
Correct, yes. He was, it was clear we were seeking damages under a contract, and he viewed it as and it may have been confused by the title of the motion saying seeking to enforce the motion, but we were not seeking to injunctive relief. We were not seeking specific performance. We were seeking damages for breach of the agreement. 6-year statute of limitations. We could have brought a separate action, but we were well within that. So questions of laches and those types of questions, which would apply to we were seeking equitable relief, aren't applicable to this. It was simply, was there a breach, and were we entitled under the contract to the $100,000? The second issue the judge relied on were the conditions in the agreement. However, those conditions were not conditions on the formation of the contract, and he found that the parties had agreed. The issues about whether it was signed by the Damianidises. Their attorney forwarded it to Mr. Hanzai, who was going to purchase the property from them for his signature, and then...
Wait a minute, did Mr. Hanzai ever sign the settlement agreement?
No, he didn't, because we got the termination notice, the repudiation notice from the Damianides' attorney occurred that day that he was coming in to his attorney to sign the agreement. So, but the sequence was set up by the attorney for the Damianides. His client signed the agreement. The parties had negotiated the entire agreement. This is what the judge found. He was correct in finding this, that they had come to an agreement. Then he he forwarded it to Mr., his name is escaping, the attorney for Mr. Hanzai's signature, and then he was to forward it to me for Mr. ZAMMUTO's signature.
If Mr. Hanzi never signed the agreement, for whatever reason, how is it an enforceable agreement?
Because under basic contract law, there's nothing in the agreement that says it only becomes effective upon a signature. You'd have to have something in the contract that said this is only effective. So you look at it and say, did they come to an agreement? Had they been a meeting of the minds?
So assuming that they came to an agreement in November 2021, back when it was really hard to get a civil trial in Superior Court,
Right.
why would your clients wait 2 years to go to the court and say, oh, we've settled the case?
Well, we're seeking damages. We're seeking damages. We're not seeking injunctive relief. And there's a question under Massachusetts law, unusually, that when there is a repudiation, you're entitled to seek damages as opposed to seeking to enforce the agreement. In most every other state, you can do that immediately. In Massachusetts, you have to wait till the time for performance is up before you can actually bring a breach of contract claim for damages. And in this case, there is no time for performance stated in the agreement. So the latest time for performance would have been while the special permit was still operative, still valid, and that didn't expire until July 23rd. So, and you're right about the lack of access to the court, but my client had the right to seek damages for the breach of this agreement. He had our positions. He had the right. He wasn't required to seek injunctive relief in front of the court. So, and he's timely under the law. It may have been a little bit inconvenient for the court. I agree that it's done on the date stayed for the trial, the hearing on it. But as far as timing matter goes, as far as enforceability, it's timely. The action is brought. It's simply a breach. I mean, he could have filed a completely separate complaint rather than seeking this relief, but this seemed to be the best way to go, is in front of the court. We have the court now, and why have a bifurcation into multiple lawsuits on this thing? And we believe the court had the authority to grant the relief here, the broad authority that the court has with respect to settlement agreements. Could have awarded us the damages, said the case is over. Thank you, thank you. So with respect to the condition, as I said, the conditions in the contract, the conditions in the settlement agreement, if you look at those conditions, most of those conditions are performances by Mr. ZAMMUTO, and I submit that he effectively performed all of them by agreeing to it. He agreed. They said the DAMIANIDIS are authorized to accept the offer. Well, authorized by who? By Mr. ZAMMUTO. It said that he agrees to cooperate in the transfer of the permits. He agreed to cooperate. The permits hadn't been transferred, but he agreed to do it. He agreed to indemnify. He signed the agreement saying he agreed. He agreed to do all the things that are in those conditions. Even if he hadn't, even if they hadn't been fully performed, those were conditions on the performance, not on the formation of the contract itself. Mr. ZAMMUTO, once the repudiation came in, was excused from having to perform under that contract. So even if there was performances left, and there were, I mean, he would have had to have gone to the town, and they would have had to sign documents and those kinds of things to transfer the permits. He's not obligated to do that once he gets the repudiation. To the extent that any of the conditions entering into the purchase and sale agreement by the DAMIANIDIS were conditions that they would perform, they cannot rely on their own repudiation for the failure of those conditions. They were obligated to act in good faith to go forward. The analogy that I use is to a mortgage contingency clause. They were obligated to make some good faith effort to go forth. So with the sale. So they cannot say because we didn't go forth, we repudiated, that condition wasn't fulfilled. That's not a defense to a breach of the agreement. So, and they have not suggested anything that would there was any real impediment to this going forward. There's been nothing presented to say, well, it wouldn't have happened otherwise if we hadn't repudiated. There was some problem with this that wouldn't have gone forward. I submit that would have been their burden in this case, that they would have had to have come forth with some reason why this would not have gone forward, other than we just decided not to do it.
Can you address the judge's finding that you did not meet your burden to prove whether your reliance was reasonable?
Okay, that's on the purchase and sale agreement and the underlying trial. So first of all, the overarching response to that is York v. Taylor. That's the law in a commercial transaction, that parties have a right to rely on representations made to them. What I submit on that is that the judges stated this, and the Damianidiis has raised this. Well, there's standards in the practice of real estate conveyancing. There's all these types of things which there's no evidence of in this case that would go against York. When you have York v. Taylor, that's the overarching law regarding this issue of justifiable reliance here. To get around York v. Taylor, I submit it was the burden of the Damianidises to say there was something that would take us outside of that. Not just argument of counsel, but some evidence establishing that this is not reasonable within the context of this particular transaction on a commercial real estate deal. There is no such evidence in the record, and the judge obviously doesn't cite to any.
I think the judge finds there's no evidence of it, right?
Yes, and he blames Mr. ZAMMUTO for that, and I'm saying that wasn't Mr. ZAMMUTO's burden. I'm saying that the law is York v. Taylor. He had a right under York v. Taylor to rely on this representation. If they wanted to get around York v. Taylor, they had the burden of bringing something in. That's essentially what's coming down. Who had the burden of bringing this material in to prevail on this? For them to get around York v. Taylor, they would have had to have brought something in to counter the overarching law on this. So, as to the damages issue on the purchase and sale agreement, we had on the pretrial prior to the trial, we had agreed to bifurcate that, and the court did find that it did make a finding that there was that Mr. ZAMMUTO had incurred costs to get these special permits. I mean, the closing was delayed numerous times for him to get the permits. There were hearings. All of this is in the evidence before the judge, and the judge found that he had incurred costs to get these permits. So as far as on liability, we've satisfied that obligation that Mr. ZAMMUTO, and that's what he's seeking here, is recovery of his costs for these under the purchase and sale under the underlying case. So we were going to bring in his wife, who was the bookkeeper for his business, with the records showing what his costs were, and then there was a dispute about whether there was some disputes about evidence, so we agreed to bifurcate it. In fact, it was the suggestion of the Damianidi's counsel to do that, so that because we had a lot of issues in front of that judge, and so we would bring in the issue on these costs at bifurcated if necessary at a later hearing. So that was the issue on the damages, and it's in the record. It's in the record. It's in the transcript of that pretrial hearing. So as far as the impracticality argument, the judge found that there was no benefit. There was no evidence of a benefit to the Damianidis from the special permit. I think the evidence is there was a benefit. I mean, they received an offer to purchase the property with the special permit, which they offered Mr. ZAMMUTO $100,000 to effect. That alone was evidence of a benefit. But also, there's law to the effect that it doesn't always have to be a benefit incurred to prevail on an impracticality. The judge was correct that it was impractical. Mr. ZAMMUTO could not go forward with that purchase. He was getting finance for the purchasing. He needed the lot for that development. It was a peculiar situation. It wasn't a typical type of error or problem with the title. They literally didn't own a piece of property that they had agreed to sell to him that was vital to the project. And so they worked out how it would be and how it could be resolved, and it would take some time to do it. And Mr. ZAMMUTO, he wasn't obligated to under paragraph 14, but he offered to pay half the cost of that. They tried to work out some kind of compromise. And again, Mr. Lash, the attorney for the DAMIANIDIS, has just said, no, we're not going to go forward with any of that. As far as impracticality, expenses incurred, and it's in the briefs with the citations, they can be considered as damages on an impracticality claim. And again, the judge found that there were expenses incurred. As to the amount of expenses, we had agreed to bifurcate and bring in a subsequent hearing. Is there any further questions? Thank you.
Thank you.
Good afternoon, Your Honors. My name is Andrew Caffrey, and I'm the attorney representing the appellees in this matter. And what we're dealing with, in my mind today, is a lot of smoke and mirrors. As my brother said, there are two issues before this court today. First is the motion to confirm or enforce the purported settlement agreement, and the second is count 2 of his complaint, and whether the plaintiff is entitled to tort damages for allegedly relying on negligent misrepresentations supposedly made by the defendants. While my clients are satisfied with the ultimate judgment made and entered by the trial judge, we suggest that the analysis made in each instance gave too much credit to the plaintiff. As to the settlement agreement, there was never an enforceable contract. Rather, the agreement that was circulated for signature was basically an agreement to make an agreement. Under this scenario, Mr. ZAMMUTO had valuable building permits. Wasn't
there evidence, though, in the record, in the exhibits of email correspondence amongst the parties that this was, in fact, what they intended?
Yes.
Yeah.
There was a framework.
Right.
There was a framework that had been agreed to, but that framework was that my clients were authorized to negotiate with Hansi, and the only thing valuable that Mr. ZAMMUTO had was the building permits, and so they said, if we reach an agreement with Hansi, if we can enter into an agreement, accept a price, accept terms, enter into a P&S, will you, in exchange for $100,000, agree to assign those to him?
And he did.
So that was the purported agreement. That was the framework. But it was an agreement to make an agreement. It was conditioned on various things. The first thing being whether they could reach an agreement with Hansi. It simply authorized him to accept an offer from Hansi. But that negotiation had not gone on. And then the other thing relative to that is it's clear from the emails and everything else that it was intended that a written agreement would be signed by the parties. And if you can see in the record,
they discussed about whether to go in person or electronic signature.
Right.
So it seems like for all intents and purposes, right, everyone was on the same page, so to speak.
yes, but this was a framework that was important. My clients couldn't go and agree to sell to Hansi unless they knew they had ZAMMUTO on board and what the terms were. And clearly it was intended that it was to be signed. My clients signed it, I think, on the 16th of the month. And it finally got signed by ZAMMUTO sometime on the 23rd, but there was no indication that Hansi was ready to sign it. 6 or 7 days had gone by, and he hadn't been able to do it. So had he withdrawn from the agreement? If he never signed it, there was no agreement. So this was, as I said, an agreement to make an agreement, and it was never signed by the parties, and it included an interest in land. So I think that a signed agreement by all parties was necessary before there was any sort of an agreement. But again, even if there was that agreement. It wasn't a contract, it was a conditional agreement. And there was a lot, before, from that until the actual sale would happen, and Hansi would get the land and the permits, and ZAMMUTO would get his $100,000, and my clients would get the balance of whatever they agreed to with Hansi, but there was no agreement with Hansi.
Wasn't the argument that, well, he was going in to sign it, but by then, before he could go in to sign it, your clients repudiated?
It's not repudiated if it hasn't been signed by all parties.
Well, that's because you're saying it's not a contract.
My clients, we believe, were entitled to withdraw. Where is Hansi? What's he doing? They get nervous about it, whatever, and they say, we don't want to go forward with this. This is too sketchy. And I think they're entitled to do that up until it is signed. And so that is what happened.
I get a little confused by Judge Saruf's use of the word moot. He doesn't cite any case or support for that. He's saying plaintiff's motion to enforce the party's settlement agreement is deemed moot. I think of that word as having to do with when a cause of action can no longer benefit somebody.
Well, I think that's the case. I was somewhat confused. I was happy, but I was confused by that term. But I think what he's saying is, by the time the motion to enforce had been brought along, the permits had lapsed. ZAMMUTO had nothing, there was no consideration ZAMMUTO could bring to that group at that point. And so at that point, it became moot because, as you...
But it might be more like impracticable or impossible or some doctrine like that to do with contracts as opposed to...
The underlying terms could not be satisfied.
But that's not mootness, right?
I think he delayed so long that he allowed the whole thing to evaporate. I suspect that if he really thought he had an enforceable agreement, he would have brought it a lot earlier than the eve of trial. I think, again, this is smoke and mirrors to my mind, but I just don't think there was anything there, and it was a Hail Mary to try to enforce that, an agreement which, again, we maintain was not really an agreement.
Did the judge address in his findings negligent misrepresentation?
I'm sorry?
Did the judge address in his findings negligent misrepresentation?
I'm happy to do that.
Did the judge address?
All we know is what he put in his findings of fact and law and judgment. And again, we think that the plaintiff is trying to practice modern alchemy here by turning a simple contract, failed P&S, into a tort of negligent misrepresentation. And while the court set out the proper terms for negligent misrepresentation, we think they that the court erred on the first element because there was no misrepresentation made. No one can point to a misrepresentation. The trial court got a little confused by talking about adjoining lots and stuff. In fact, the lots do adjoin. It's just that title to a strip of one of them was missing or was defective, but the lots do adjoin. The misrepresentation my brother is focused on is the misrepresentation that the sellers had good, clear title to the property, and they did not. However, that was not their fault. That had come up, I believe, when they bought the property, and in 2010 they engaged an attorney to correct the title problem. The attorney opened probates in seven different families to get permission to convey the 12-foot strip to my clients, and that's what he did. However, apparently he was deficient in not getting licenses to sell from each of the probate courts, and so when the title was finally examined, that came up and the attorneys agreed that title was defective. But there is no representation by the sellers that they gave any false information. They honestly believe they had corrected this title problem. The other significant thing, I think, is that this P&S drafted by the buyer's attorney called for the sellers to convey by quitclaim deed. And quitclaim deed is different from a warranty deed. In a quitclaim, you're selling what you have and saying that during our ownership, we have done nothing to create any encumbrances. Under a warranty deed, it's a little bit different. It's quite a bit different, actually. Under a warranty deed, you're warranting that you have good title to the property. And this was not by warranty deed. This was by quitclaim deed. And so I think that's a significant part of it. So there was no representation made. In fact, under paragraph 20 of the purchase and sale agreement, the buyer acknowledged that he had not been influenced, nor had he relied upon any warranties or representations not set forth in the agreement or previously made in writing. Other than agreeing to sell them 29 and 41 Alden Street, there's no evidence that the defendants made any representation regarding title to the properties. And then we go on to responsibility. It is the buyer's responsibility to have the title examined to ensure that the sellers have proper title to the property and that they can convey it. It also is important, particularly for a developer, to understand whether there are any easements or covenants encumbering the land. Now, if the neighbor had the right to park 12 cars on the property by some covenant that was in place, that would have impacted ZAMMUTO's ability to do his development. So he needed to know that. If there was an easement across it, if rather than there was a strip of title missing in the middle, if the neighbor out back had the right to drive his cars through the middle of the property, that's something he needed to know. And a title exam is a minor task. It has to be, it was going to have to be done by the attorney for the bank anyway. And so before you go expending all this money on lawyers and engineers and architects, reasonableness is to examine the title to make sure you understand what you're buying and that the seller has good title to it. So that was really irresponsible and unreasonable of Mr. ZAMMUTO to go ahead with all of this engineering and stuff before he knew what the status of the title of the property was.
I have a question for you about the judge's findings. He said, and this is at page 86 of the Record Appendix 3, a final version of the settlement agreement was accepted by all three parties and the document was delivered for the parties to sign. There is no question whatsoever that an agreement was reached. But I hear you saying that Hansi never signed the agreement. So
Correct.
is that clearly erroneous?
There was an understanding reached by the attorneys with the emails and the drafting of the purported settlement agreement, but Hansi never signed it. My clients withdrew, and that was the end of it until the motion to enforce was brought.
So do we need to remand it to him to find out whether or not that means an agreement was reached, means a settlement agreement was reached?
I would hope not. But, you know, I think the bigger thing is his ultimate finding that ZAMMUTO let the value of the whole thing dissipate by waiting until the eve of trial to bring this motion. I mean, that's why, you know, the judge decided that that issue was moot, that he had let it evaporate.
What do you say to his argument that ZAMMUTO had to wait until there was no longer any possibility of performing, I guess, or?
I don't know. I mean, it was a conditional agreement. It was never signed. In our mind, there was no agreement. And even though the judge made that finding, we think he's in error on that because, again, as we said, it was an agreement to make an agreement, it was conditional, it was never signed by all the parties to it, it involves an interest in land, and I think all of those things were necessary. So we think the judge was in error and that this court should find that, in fact, there was no enforceable agreement between the parties.
But you're happy with the result that the judge came down with, even though you're admitting that, and sort of admitting on other points that there was error, that he did in fact, in terms of the analysis or how he got to where he got or what he called, you know, moot or not, correct? Like, what are you willing to sort of admit to with respect to the error in terms of the judge's findings?
Well, we think he made errors, but the errors were
in your favor.
Well,
right?
The ultimate decision was, but to say there was an enforceable agreement, we think is an error.
Right. So what do we?
It doesn't hurt us ultimately.
Right.
But we think that, you know, this court should understand that we don't agree with that. Same thing in terms of the misrepresentations. We say there were no misrepresentations. This was, as I said, just a defect in seller's title, which the sellers are not aware of and not at fault.
But so what happened in front of him ultimately? So could we revisit the question of whether or not a settlement agreement was accepted
No, I think on the record, you have all you need to make a determination that there was no ultimate agreement between the parties, because it wasn't signed, and just the nature of the document itself. It wasn't a contract. It was a framework authorizing my clients to negotiate with Hansi, but they needed to know that ZAMMUTO would pass on the permits, because that was going to be critical. That was going to be certainly a condition of Hansi's any P&S that he might enter into. So it was just a framework to ultimately resolve this if my clients reached an agreement with Hansi. If they didn't, then it was null and void. It was no further consequence. I mean, as I say, this is really just an agreement over a purchase and sale agreement. And I think the case of Saul v. Kwiatkowski, I think it is really right on point. And in that said, a defect in the seller's title of which the seller is not aware and not at fault after the agreement is entered into voids the agreement without recourse between the parties, entitling the buyer only to a return of their deposit. Now, in that case, the defect, I think, was a tax lien that happened after the agreement, but the sellers didn't know about it. In this case, the title defect had existed for some 10 years, but again, I don't see any difference in it because my clients did not know that that strip of land and the actions taken by the attorney were not sufficient. So this is just a breach of contract. The parties had allocated risk. They'd agreed that paragraph 12, return of your deposit, and everybody walks away without recourse. Thank you.
Thank you. Thank you to the parties. This case is now submitted, and this is also the last case of our sitting today. So this concludes today's sitting. Thank you.